Three cases are now called 22-40954 is a motion to revoke probation. That's the older case. And then there are two new cases that are newer cases, 25 CR 858 and 859. Does the defendant waive formal readings of the indictments and the arraignments in these cases? Can we proceed in summary?
Yes, sir.
Everything's going to run concurrently, correct? No,
Yes, sir.
This is all running
It's all
together.
different. Yes, sir.
All right, I'm going to take up the two new cases first in order, 25 CR 858 and 859. In 858, and in these cases, the defendant waives formal readings of the charging instruments. We can proceed in summary. In 25 CR 858, sir, this indictment alleges that on or about March 5th, 2025 in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here, Fred, in this case?
Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed that cannot exceed $10,000. Do you understand the punishment range in this case?
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 20 years in prison to run concurrently with other cases. Is that your understanding of the agreement?
Yes.
What is he going to do on an MTR plea?
5 years.
Okay, so it will run concurrently with that case as well.
Yes, sir.
It's not written here.
Yes, sir. All there. Okay.
So this would run concurrently with the next case we're going to go into, 859, and the probation case that we're going to be handling in 22-40954. Is all of that true and correct?
Yes, sir.
Yes.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir, of this first-degree felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily because you are guilty?
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. I'm going to hold this in abeyance for just a minute. I'm going to go into the next case pending, 25 CR 859. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that also on or about March 5th, 2025 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child by sexual contact. Do you understand what you are charged with in this case?
Yes, Your Honor.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in this case where you would be pleading guilty, also sentenced to 20 years in prison to run concurrently with 25-0858. And let me add this other motion to revoke probation case 22-40954. Is that all true?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this case as the previous case, guilty or not
Guilty.
guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
On each of these cases, I'm showing you what's marked. These two cases you have pleaded guilty to. I'm showing you what's marked as State's Exhibit 1. Did you sign those documents voluntarily in each case? Understand them, discuss them with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without
Okay.
objection admitted. Among other things, these states you were mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each case. All true, so help you God.
Yes.
States Exhibit 1 in each case made a part of the record. Pre-sentence reports are waived here.
Yes.
On these two cases, I'm going to follow these agreements and find in each of these cases you have pleaded in 25 CR 858, the first degree felony of aggravated sexual assault of a child, and in 25 CR 859, the second degree felony of indecency with a child. You have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
There is sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in these hearings to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of these two felony offenses. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years confinement. In each of these cases, these sentences shall run concurrently.
This case just escalated quickly. We're talking about not one, but two felony charges: aggravated sexual assault of a child and indecency with a child. The judge lays out potential life sentences, but notice how fast the plea bargain shifts everything. Instead of 99 years, it's 20 years running concurrently. But is justice really being served here? Or is the system trading severity for efficiency? Stay tuned, because what follows gets even more complicated.
What this means also is that you have additional obligations of filing documentation, and you are going to have to register as a sex offender. And because this aggravated sexual assault involves a child younger than 14 years of age, this is going to be for life.
Yes, sir.
You're going to have to register, and failing to register properly can result in the filing of a felony charge and additional prosecution. So you have an affirmative obligation. The probation officer, when they go over this judgment with you, you're going to be able to do that, to explain to him
What do you need to explain, Joe?
the obligations of registration under the sex offender laws. And do we do that immediately through y'all, or is that done through the jail? Because he's got to do that immediately. And I don't have paperwork here. How do we get that accomplished?
What document specifically is it that we reviewed?
Sir?
What
I
documents?
don't know, well, he's got to register under the sex offender program.
I think
And
based being sensitive.
But I'm not telling him how to do that. He just has the obligation. It has to get done. Somebody's got to help him with that. He's not on probation.
I think when
going
he is released, parole, I think they.
I think he's got to do it before he's released on parole. I think.
While he's in custody, I don't think he has a duty.
They'll handle it.
Until he's released.
Correct. I agree with that.
So they'll take care of that once he's released.
Okay. Well, the prison authorities will know that he has that obligation, and they know what his convictions are.
And his parole.
They can take care of the necessary within the institution for security based upon those matters.
We do have the notice that's normally signed by defense counsel and the defendant today, Judge. That's on the tablet. That should be done. While you're looking at that, Judge, I've made contact with the family about the plea, but they weren't able to be here before the entry of the plea today. I will confirm if they still want to do an allocution And we may schedule it later this week, Your Honor.
Did you do that, Mr. Joseph? We may need to bring the defendants back, because they have a right under the law
They do.
to,
Mr. Hampton, let me know.
Yes, sir.
confront the defendant and allocute on what, harm has occurred here. But I don't see anything in the tablet that.
I don't think it's been done by the defendant, Judge. I think it needs to be done. See.
In 22-40954, does the defendant waive a formal reading of this motion to revoke probation here? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. In summary, this motion to revoke probation filed on May 28th of this year. It states that on April 10th, 2023, in this court, you were sentenced to 10 years in prison, and that was probated or suspended for 10 years for the third-degree felony of theft of property. Is all of that true and correct, sir?
Yes.
Now, this is huge. Registration as a sex offender for life. That means every time this man moves, changes jobs, or interacts with the community, the system tracks him. Failure to register? Another felony. This isn't just about serving 20 years. It's a lifetime label. Let me ask you, do you think lifelong registration is enough justice for crimes this serious? Or should the sentence have been harsher from the start? Drop your thoughts below.
So you were convicted, sentenced to 10 years in prison, placed on probation for 10 years. And this motion alleges that you have violated that order of probation. I don't see anything. There are no allegations about the two substantive crimes he just pleaded guilty to. All right. Number one violation states that you committed the offense of illegal possession of a controlled substance on or about March 10th, 2025 in Hardin County, which was in violation of condition 1 of your probation order, which states don't commit a crime. Is that true?
Yes, sir.
Are you pleading true to that voluntarily? Because it is true as it is alleged.
Yes, sir.
Do you understand that a knowing and voluntary plea of true, one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced to no less than 2, no more than 10 years confinement in prison. So for this third-degree felony of theft. Understanding that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. And then finally is allegation 6. This states that you violated your probation by failing to remain in Jefferson County, Texas, and that you were in Hardin County, Texas on or about March 10th, 2025 without permission from the Jefferson County Adult Probation Officer Department or this court in violation of your probation order. Is that true?
Yes.
And are you pleading true to that voluntarily because it is true as it is alleged?
Yes, sir.
And again, the same warning, do you understand that a voluntary and knowingly made plea of truth to one or more violations of probation, that is a grant, the motion to revoke probation. The probation can now be revoked and can be sentenced no less than 2, no more than 10 years confinement in prison. Do you understand?
Yes.
Knowing that, you insist on pleading true today.
Yes, sir.
I find you are pleading true voluntarily to this allegation as well and this motion to revoke probation, and you understand and appreciate the consequences of pleading guilty. An agreement's been reached where your probation would be revoked and you would be sentenced to 5 years in prison to run concurrently with these other cases. Is that true?
Yes, sir.
On top of the child assault cases, we now see probation violations, illegal possession of a controlled substance, and leaving the county without permission. These may sound minor compared to the felonies, but legally, they're enough to revoke probation and add more prison time. Think about it. He had a second chance, already on probation, and still broke the law. What does that say about rehabilitation versus punishment? Would you have given him another chance or slammed the door shut?
Stand by. So. Add this since If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
Okay. This states the case will run concurrently. This probation revocation will run concurrently with 22-41105. I don't know what that is.
The was a prior motion to revoke state jail felony. He was previously sentenced to 2 years state jail.
You're asking it also run concurrently with these other two cases, correct?
Yes, sir.
All right.
But that's not in here. I'm gonna add that. If that right, that's okay with everybody?
Yes, Your Honor. That is a party's intention.
Okay. I find there is sufficient evidence, again, supporting this motion to grant it by a preponderance of the evidence or greater as allegation 1 and 2 of the motion to revoke probation dated 5/28/25 and this cause number 22-40954. Those allegations are found true. Your probation is hereby revoked. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years in prison. And this sentence, in this case, shall also run concurrently with the sentences.
And there it is. The hammer drops. The probation is revoked, and he's sentenced to 5 years. But because it runs concurrently with the 20-year sentences, the total doesn't actually increase. In effect, the new punishment folds right into the old one. It's a powerful reminder of how plea deals and concurrent sentencing shape outcomes in ways the public rarely sees. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
In cause numbers 25 CR 858 and 859 of 20 years confinement in prison that have been set earlier through the sentencing of this court in accordance with the plea agreements in those other two cases. Anything else to add?
No, sir.
That is all.
Here's Stephen.
Thanks, goodness.
Thank you, sir.
Thank you.